Hi, everyone. Welcome to the Friday Flash. I am Lori Cantu, your concierge for all your title and escrow needs. And today with me, I have Shannon Patterson, your title girl. And we have a very special guest. His name is Mike Lynch. He's a sales executive out of our East Side King County office, and he's been in the industry for a few years, quite a few years, and he's so knowledgeable on so many topics, and he's personally helped me and my clients out with the topic of FIRPTA. So we thought we'd bring him on to answer some questions.
Yes, FIRPTA is one of those subjects that I never seem satisfied that I know enough. So we're so glad that you've joined us today.
My pleasure. I'm always happy to help you guys out. I mean, that's one of the benefits of working with Fidelity. We have a fantastic team of people, not just one or two.
Excellent.
So true.
Well, Mike, could you tell our viewers what is FIRPTA? What's it stand for? And just give us kind of a overview of it.
Sure. So FIRPTA stands for the Foreign Investment in Real Property Tax Act. And what it basically is it's a withholding that's required for foreign sellers when they sell real estate in the United States. Now, one of the benefits that the United States has is you can own real estate. It doesn't matter whether you're a citizen or not. So you can invest in the United States, buy real property, and you don't have to be a citizen to do that. That's not the case in many parts of the world. But in doing that, what the United States has done, and the IRS has said that when you're a foreigner, when you sell, they're going to do a backup withholding, and the backup withholding is in most cases 15% of the gross sales price. There are a couple instances where it might be 10%, but a good rule of thumb, especially in the Seattle metro area, is that it's going to be 15% of the gross sales price. And it's withheld from the seller's proceeds at the time of closing and sent to the IRS.
Wonderful explanation. Thank you. So, Mike, who's responsible for this? Is it the selling agent, the buyer, the sellers, the buyers? Who's responsible? Escrow? Who needs to let us know about this?
Sure, absolutely. So you would think that that maybe the escrow agent would be responsible for this because they're the ones that are handling the money. And I've had a lot of real estate agents tell me that they thought it was escrow's responsibility. But what the IRS has actually said is that it's the buyer's responsibility. Not only is it their responsibility to make sure that it happens, but they're charged with determining whether or not the seller is a foreigner and subject to the withholding, ensuring that the money is withheld and that it is transferred to the IRS at closing. And if they don't fulfill that requirement, they're subject to liens in the amount of what the withholding would have been on their property.
Yikes.
Yeah, and one more point about that. So escrow, recently there was a change with the Limited Practice Board, which is regulated by the Supreme Court of the state of Washington. And it specifically says that escrow cannot complete those forms, the transmittal forms for the withholding that have to go to the IRS. So escrow cannot prepare those.
Okay.
Speaking of forms, Mike, you know, the agents have forms, we have forms. Who fills out these forms?
Right. So there are some transmittal forms that are required to be filled out when escrow sends the money to the IRS. And the forms, it's the buyer's responsibility that the forms be filled out. However, the seller is the one that is providing information onto the forms. So most times the seller will contract with a CPA or a tax attorney to fill out the forms for them, and the CPA or attorney will communicate with the buyer or the buyer's agent to get the buyer's part of it, because the forms, the transmittal forms, actually ask for both the seller's tax ID number, tax identification, and the buyer's tax identification. And that gets transmitted to the IRS.
And another word for that tax identification is TIN number, right? We've seen that word.
Correct.
Okay.
Yeah, so a lot of times you'll hear, do you have a social security number? Do you have a tax identification number? Now, a lot of sellers don't actually have a tax identification number, and they can't get the tax identification number until the transaction closes and they make this application to the IRS for a tax identification number. So that's another reason why it's really important to have a tax professional involved, because there's some communication with the IRS. And as far as the transmittal forms, if there's a discrepancy in the form, like if the information that the seller put down is different than what the buyer put down as far as their names, how their names are and what the addresses are, then there's a possibility that the IRS could not be able to match up the buyer and the seller and the property and not think that the withholding was done and still try and attach to the property. So it's critical that those forms are filled out correctly, and that's why you need to have a professional do it.
Yes. Okay. So what are some of the exceptions the common exceptions that we see when it comes to FIRPTA?
Yeah, so the two main exceptions, actually there's three main exceptions that you're going to see that the MLS has dealt with, and one of them is if you're a U.S. citizen, you're not subject to the withholding.
Okay.
If you have a green card, so you're a permanent resident alien, you have a green card, you're not subject to the withholding. If the sales price is $300,000 or less, and the buyer is willing to sign a statement that they are going to occupy the property, it's not subject to the FIRPTA withholding. There's another one that's less common, but in this area it's probably more common than other parts of the country because it has to do with how long you've lived here, and it's called the substantial presence test. And it has to do with a number of months that you've been in the United States living here in the last 3 years. So that is one that a lot of people that are here on work visas would qualify for. So they may not have a green card, but they may still be have an exception to the FIRPTA withholding. There's 10 other ones. This is a really complicated law. And there's several of them, some having to do with treaties and things. And it's nothing that a real estate agent or a title rep or somebody that's not a tax professional could really advise a client on. So one of your best practices for a real estate agent is to have conversations with a couple different CPAs or tax attorneys, have them available to refer to their client to consult with, because you're never going to want to ask anything other than, are you a citizen and do you have a green card? Anything other than that, you're going to want to have a tax professional answer that question for the seller.
So, Mike, one of the things that I heard you say is that ultimately, if things aren't done correctly or taken care of up front, that this could become a lien on the property for the new buyer. Correct. How can the buyer protect themselves?
Yeah, absolutely. So there is a publication form about FIRPTA withholding that the IRS has called Publication 515, and in that form specifically, or in that publication specifically, it says that if a buyer obtains a statement from the seller that upon penalty of perjury, there's specific language that it has, that even if the seller misstated or misunderstood their status and made an incorrect statement and was subject to withholding, if they got that statement, then the buyer would be protected and the IRS couldn't lien them. So the MLS has already created a form that has that on there. It's called Form 22E, and it has the specific language there. So I'm going to share my screen here real quick, and I will show you what the form looks like. All right, can you see my screen now? So it says FIRPTA certification here. So this is called Form 22E, and right here is the question that the seller would answer. And it says, In this particular case, the wording is a little bit cumbersome, but they're going to answer, I am not a non-resident alien or a foreign corporation, foreign partnership, foreign trust, foreign estate, foreign business entity for purpose of U.S. income taxation. So they want to check the I am not. If they sign that statement down here, and they're not going to put their tax ID number on this form, this is not something that is going to be needed up front when you're entering into a transaction. But the escrow company is likely to ask them, or the selling agent can have the escrow company ask the seller for that to be held. But all that needs to happen is that the seller sign that affirmation there upon penalties of perjury, which it says right down here, and they keep that form for 5 years. And as long as they have that, then the IRS can't lien the property.
Thank you for that visual.
Yeah, that was great.
Yeah, this is a good example.
Let me unshare my screen now. How do I unshare here? Oh, there we go. Sorry.
No worries. Well, thank you so much, Mike. That was really good information. And we would like to say to our viewers, if you guys have any further questions about FIRPTA, please feel free to let us know. You can email us, you can make comments, or reach out to us however you like to. But this is going to be a wrap for our 8th Friday Flash. And so we wanted to wish you a very, very happy 4th of July. Stay
Happy 4th
safe.
of July. We will be.
Yeah, happy 4th of July, everybody.
Yeah.
Okay.
Thank you.
Bye.